Ready for dictation, start. In view of the judgments of the Supreme Court in T. Lakshmipati's case, bracket 1 Supra, Tanushri Basu's case, bracket 4 Supra, and Jafuri Shah's case, bracket 3 Supra, we hold that even if the appellant and respondents are said to be joint family members, if the appellant is able to establish his exclusive possession of items 4 and 5 and the fact that respondents 1 to 4 are trying to interfere with his possession and enjoyment thereof, he would be entitled to get a temporary injunction pending suit. Para. It is not in dispute that respondents 1 to 4 are married and are staying with their respective husbands. It is not pleaded by respondents 1 to 4 that they had ever managed the function halls in items 4 and 5 of plain schedule exclusively. Their plea is that they are deemed to be in possession because they are co-owners along with the appellant. Para. In the affidavit filed in support of IA number 1615 of 2016, there is a clear pleading by the appellant about the attempts of the respondents 1 to 4 and their husbands who interfered with the running of function halls in items 4 and 5 of the plain schedule, and there is also a clear reference to the police complaint dated 7/11/2016 given by the appellant against the husbands of the respondents 1, 2 and 6. A reading of the said complaint shows that the appellant had alleged he was beaten up by his brothers-in-law. Locks of the function halls were broken open by them, and that they had taken away the register books and important land documents available in the function halls. The said police complaint was filed along with the counter affidavit by the appellant, but the same was not taken note of by the court below. Para. Therefore, it cannot be said that the appellant was not entitled to have an apprehension about his disposing by respondents 1, 2, 4 and 6. Para. In our opinion, respondents 1 to 4, having got married and staying with their spouses, would not prima facie be running the function halls, and since the appellant was the only male child of his parents, naturally he would be running them, though his possession might be on behalf of other co-owners. That does not entitle the respondents 1 to 4 to interfere with his running of the function halls in items 4 and 5 of the plain schedule and attempt to totally oust him from possession thereof. Para. Counsel for respondents 1 to 4 also contended that there was no temporary injunction in favor of the appellant from 2016 till date, and therefore he ought to be denied the said relief. Para. Due to steep fall in the strength of judges in this court was not able to take up this CMA at an earlier point of time. Para. It is settled law that mistake of the court should not cause prejudice to any party. Therefore, the fact that for the last 2 years there could not be any disposal of this appeal cannot be a ground to deny relief to the appellant at this stage. Stop.